Welcome to You Counsel. You may be involved in a court action in Ontario where some of the important and relevant documents to your case are in the possession of a non-party. A non-party is a party that is obviously not part of your legal proceeding as a party. It's not a defendant, it's not a plaintiff, it's not a named third party. So it is not part of your court action. It is someone who is unrelated to your court action as a party. And that person, that party has some documents which are crucial to your case, and you want those documents to be produced. You want to get those documents so you can use them as evidence in your trial in support of your case. So how do you go about getting those documents? Today's lecture explains how this can be done through Ontario's Rules of Civil Procedure. This lecture is for educational purposes only, so if you have any specific questions, you should contact a lawyer or a paralegal or Law Society of Ontario for any referral. I will explain today's rules by way of an example, and we'll take the example of a defamation case. Let's say you have sued a party for making defamatory statements against, and your understanding is that some of the defamatory statements were made in writing to a non-party. The defendant may have sent an email or a Twitter posting or a Facebook message or a text message of any kind, and that documentary evidence contains defamatory statements against you, and you want those defamatory statements, that document, to be produced to you so you can use it at trial. Obviously, you are entitled to get that document from the defendant through the discovery process. But this may be a situation where the defendant may not have that document. For example, the defendant may say that email was deleted a long time ago and they don't have any possession of that email. Or they may even deny the existence of such an email or such a document. But you know that a non-party does have that document and you want to get that document because it is relevant to your case at trial. This process of discovery of that document is part of this larger process of discovery in a court action. If you don't understand what a discovery process is, I do have 2 lectures on this topic which will give you a sense of what the discovery process is and how do you get the best results out of the discovery process by getting all the relevant documents, producing all the relevant documents, and obtaining all the relevant documents. The rules that deal with the discovery process in the Rules of Civil Procedure are 29.1.01 to 33.08. You can read those rules to understand fully what the discovery process is and watch my lecture on this. Today we're dealing with, within the discovery process, we're dealing with the specific issue of production from a non-party. So obviously you will try and contact the non-party and request that the production of that document, a copy of that document directly from that party. You can send them an email, make a phone call, or write a letter and ask for that. And if they provide it to you, then that's fantastic. You have a copy of that document. But what if they refuse to give you that document? Then your option is to bring a motion under Rule 30.10. This motion will allow you to get a court order from the court that will compel the non-party to give you the document which is relevant to your case. In some circumstances, the non-party may be willing to give you the document, but they will give you the document only if you get a court order. And this may be a scenario where the non-party may respond to you and say that they don't want to offend the defendant, they want to have a good relationship, or they have other relationship with the defendant which could be jeopardized by them voluntarily giving you that document, but they're okay to give you the document if there's a court order, because then they're simply complying with the court order, and in that situation they don't have a choice. So that may be a situation where bringing a motion, getting a court order may be a better way of proceeding to get the production of that document. What would the court consider in issuing that order? There are generally 2 things. Number 1, the document has to be relevant to a material issue in your case. If it is not a relevant document, the court will not give you the order. So you will have to show to the court how that document helps your case, how it is relevant to your case, and how, if you have that document, you will be able to prove one or some of the important points of your case. Secondly, the document should not be privileged. A privileged document, in a very loose way, if I guess document can be considered sort of a confidential document. But privileged document has a specific definition. I may be able to do another lecture and explain to you what the privileged documents are, but I'm not covering that in this lecture. Some of the privileges could be litigation privilege, solicitor-client privilege. Solicitor-client privilege documents are documents that are exchanged between a lawyer and his or her client. So there are documents that are privileged, meaning that they're not available to the court unless the court reviews the documents and orders that either they're not privileged or despite their privilege, they must. So if that is the case, if the non-party says that the documents are privileged, then the court has the power to inspect the document. So you won't see the document. The non-party will bring the document to the judge, and the judge will review the document and determine A, whether it's privileged or not, B, whether it ought to be produced even if it's privileged. The court may even make an order saying that parts of the document may be redacted and the remaining can be produced as part of the production in this discovery process. So that is all in the power of the court. What you want to remember is that bringing this motion, the procedure to follow is the same that is specified in Rule 37. Rule 37 is the broad rule that explains to you the process of bringing all kinds of motion in the court system. And I have done a few lectures on motions in my channel, so please review those if you don't understand how to bring a motion in the court system. The main thing that you want to keep in mind is that if you're bringing such a motion, then you must serve the notice of motion on all parties that are part of your court action, and also serve the notice on the non-party on which you are seeking the order. So in essence, what you want to remember is that discovery is a crucial process in the process of fighting your case, because this process allows you to gather all the evidence that you need to prove or disprove the case. If you want to prove the elements of defamation, you will need to show what evidence indicates or confirms that there was really defamatory statements made by the defendant against you. So you will have to gather all the documents, and which is why the discovery process is important. The main thing that you want to get from this lecture is that even if you find that a non-party has documents that are relevant to your case, you should not worry about it. This is the process that you use to obtain those documents from a non-party and are able to fight your case in court. Thank you for watching.